Okay, Commissioners, it looks like the attendee list has populated and we're ready to get started.
All right. The regular meeting of the Civil Service Commission for January 7th, 2026 will now come to order. Happy New Year, everyone. Welcome in person and online attendees. If you would like to provide oral comments on any of the agenda items, please be sure to follow the instructions on the first page of the agenda. If you're attending this meeting in person and you would like to pull an agenda item for discussion, when asked, please stand and identify yourself by name or number, and we will return to your item after the consent agenda is approved. Attendees joining this meeting using the Zoom application will alert Commission staff of your intention to speak about an agenda item by using the Q&A function at the bottom of the screen. Please include your name, telephone number, or other identifying feature you selected when logging in, and the agenda item number you want to speak about. Attendees who just dialed into today's meeting, please use *9 on your telephone to raise your hand to alert Commission staff of your intention to speak about the agenda item. When called upon, when called upon to speak, please unmute yourself using the *6 on your telephone. Our first item of business is a roll call. Will the Commission Secretary please take the roll?
Commissioner Bassett.
Present.
Commissioner Coleman. Commissioner McGovern.
Present.
Commissioner Montenegro.
Present.
Commissioner Rodriguez-Kennedy.
Present. The next item is the approval of the minutes. May I have a motion to approve the minutes of the regular meeting of the November 5th, 2025 Civil Service Commission meeting?
We approve the minutes.
There's a motion by Commissioner Vice President Coleman. Is there a second?
Second.
There is a second by Commissioner Montenegro. Is there any discussion? Seeing no discussion, will the Commission Secretary please record Commission votes?
Commissioner Bassett.
Aye.
Commissioner Coleman. Commissioner McGovern.
Aye.
Commissioner Montenegro.
Aye.
Commissioner Rodriguez-Kennedy.
Aye. And that motion carries with a unanimous vote of all present. The next item of our agenda is non-agenda public comment. Members of the public may address any matter relating to the Civil Service Commission other than items that are on today's agenda. The total amount of time allotted for public comment will be limited to not more than 2 minutes unless the Commission President agrees to extend the time. Do any of the attendees want to make a public comment about any matter relating to the Civil Service Commission, but not on today's agenda? If so, and you join the meeting using Zoom, please use the Q&A function at the bottom portion of your screen to inform Commission staff. If you dialed into today's meeting, you may press *9 on your telephone to raise your hand to alert Commission staff. When called upon to speak, please unmute yourself using the *6 on your telephone. We'll need a minute to wait a minute in the event somebody wants to make a comment and is attempting to alert staff now. Will the executive officer please start a timer?
Yes.
Commissioners, 1 minute has passed and we've received no request to make a public comment.
All right. We will then move to the agenda item, to item D, which is agenda item discussion. Before, do we talk about taking item
number 6?
So I will say it now.
Yeah, you can say it.
Just for the record, item number 6 has been pulled and will come back to the Commission at the next meeting.
Yes.
At the next meeting. So item number 6 is no longer on the agenda. Is there any other discussion? Then, do any other of the attendees want to pull an agenda item for discussion? If you're attending this meeting in person and would like to pull an agenda item for discussion, please stand and identify yourself by name or number, and we will return to your item after the consent agenda is approved. If you are speaking for an appellant or complainant, please use their assigned number. If you join the meeting using Zoom, please use the Q&A function at the bottom portion of the screen to inform Commission staff of the agenda item you want to speak about. If you dialed into today's meeting, you may press *9 on your telephone to raise your hand to alert Commission staff. When called upon to speak, please unmute yourself using *6 on your telephone. We will need to wait a minute in the event somebody wants to pull an item off the agenda and is attempting to alert staff now. Will the executive officer please start a timer?
Yes.
Does anybody in the room want to pull an item for discussion? Okay, you don't have to, make sure you don't give the employee's name. Okay.
We'll get to that when we talk about the item. We'll first adjudicate the pull. Well, it's already pulled. We'll pull it and then we'll talk about that when we go to it.
Yes. Make sure.
All right, that's time. Seeing that commissioners, 1 minute, or that's your part. I was about to read your script, but I'll say it. 1 minute has passed and we have not received requests to pull an item for discussion. So we will now move on to the formation of the consent agenda. Will the commission secretary announce the items forming the consent agenda?
Yes, Commissioner. Item 1 and 5 and item 7 have been pulled for discussion. Item 4 has been pulled for discussion?
No.
No. Okay. Item 4, 8, 2, 3, and 9 form our consent agenda.
Is that good? There's some movement here, so
Yeah.
sure we're right.
Okay, so 1 and 5 are automatically pulled for discussion. 2, 3, 4,
Mm-hmm.
8,
8
and
and
9.
9. Yeah.
Yeah, go on the consent agenda.
So the agenda for the record is items 2, 3, 4, 8, and 9.
Mm-hmm. Yes.
Outstanding. May I have a motion to approve the consent agenda as
So
submitted?
moved.
Is there a second?
I'll second it.
There's a motion. Hold on. Let me make sure I'm on the right page of the script. There we go. There is a motion by Commissioner McGovern to approve. There is a second by Commissioner Bassett. We already had public comment. Will the commission secretary please call the roll or call the commission record commissioner votes?
Commissioner Bassett,
Aye.
Commissioner Coleman,
Aye.
Commissioner McGovern.
Aye.
Commissioner Montenegro.
Aye.
Commissioner Rodriguez Kennedy.
Aye. That motion carries with all commissioners voting in the affirmative. We will now go on to the discussion items. Agenda item 1 is pulled for discussion, which is the election of officers for 2026. So this is my last time as the president for this year, and apparently we've decided to stack the agenda with all sorts of crazy things. But I am happy to pass this on. So may I have a motion for the election of president of and vice president of the Civil Service Commission?
I move to nominate Commissioner Coleman for president and Commissioner Montenegro for vice president.
There's a motion by Commissioner Bassett to nominate Commissioner Coleman for president and Commissioner Montenegro for vice president. Is there a second?
Second.
Is there any discussion? Well, I will say this is a great team. I've loved working with you as the Commissioner Coleman as vice president. I'm sure you will lead very well, and I'm happy to turn over some of these complex cases over to you. So I will. What were you pointing? Oh yeah. Well, as soon as we vote, I'll definitely do that. Okay. So do we have a second? Is there any
Yes.
other discussion? Will the commission secretary please record commissioner votes?
Commissioner Bassett,
Aye.
Commissioner Coleman, Commissioner McGovern.
Aye.
Commissioner Montenegro.
Aye.
Commissioner Rodriguez Kennedy.
Aye. This is great because I just took over the convention center and the party. So like I have a lot of things on my plate. Here you go. Madam President.
Thank you. Well, it's indeed an honor to fill this role, and it's a big challenge to fill the shoes of Commissioner Rodriguez Kennedy. I have enjoyed working with you. You've been exemplary as president, and I wish I could keep you doing all of the talking because you do it so well. So again, you've been fabulous. Thank you for your service, and we're glad you're not leaving the commission.
You, Madam President.
And now do I move to agenda item 4?
No, you can skip that. That one.
Okay.
Consent. So you can go to agenda item number 5.
All right. So the result of the votes were unanimous, and I can move to agenda item 5, which is my report on a discipline hearing. Do any of the attendees want to speak about this agenda item? If so, and you join the meeting using Zoom, please use the Q&A function on the bottom portion of your screen to alert commission staff. If you dialed into today's meeting, you may press *9 to raise your hand and to alert commission staff. We will need to wait a minute in the event somebody wants to speak about this agenda item and is attempting to alert staff now. Will the executive officer please start a timer?
Yes. Commissioners, 1 minute has passed. We've received no requests to speak about this agenda item.
Okay, hearing none, Commissioner Montenegro, as Vice President, will you please chair this portion of the meeting as I read my report? Thank you. Okay, appellant 2025-007P employee appealed an order of immediate suspension, suspending him without pay from the position of deputy sheriff in the sheriff's office, which was presented to the Civil Service Commission. The commission appointed me, Commissioner P.K. Coleman, to hear the appeal and submit findings, conclusions, and recommendations to the Civil Service Commission. Thereafter, a hearing was held on October 17, 2025. The causes of discipline were failure of good behavior and acts incompatible with or inimical to the public service. Additionally, Civil Service Rule 7.2.1b regarding whether emergency circumstances exist in which the immediate removal of the employee is essential to avert harm to the county or to the public is relevant to this appeal. Findings of fact. At the beginning of the hearing, the employee, through his legal counsel, asserted his Fifth Amendment right against self-incrimination and indicated that he would not be testifying in this hearing. In fact, when called to testify by the department, the employee did not answer any questions, again invoking his Fifth Amendment right against self-incrimination. The employee, however, did not object to the admission of all exhibits presented by both he and the department. Accordingly, the undisputed facts are limited in scope as presented by the department, including such inferences as may be legally allowed in the light of his Fifth Amendment assertion. On August 29, 2024, the employee was working his assigned shift at the San Diego Central Courthouse, located 1100 Union Street, San Diego. On that same date, an incarcerated person was housed in the San Diego Central Jail. The IP had a scheduled court appearance on the 12th floor of the courthouse. On the morning of August 29, 2024, the IP was transported to the courthouse from the central jail and was placed into holding cell J4 in the basement holding cell area of the courthouse, awaiting his hearing. Following the hearing, at or around 11:54 a.m., while escorting the IP back to his holding cell, the employee and the IP verbally argued about the force by which the employee was exerting on the IP to increase the pace of his walking. At all times, the IP was bound by leg chains and cross waist chains to restrict his movements. While escorting the IP to his holding cell, the IP stopped to speak to another IP, and the employee grabbed the back of the IP shirt and forced the IP to turn away and continue walking along the corridor. The employee used this control to walk at a faster pace than the IP felt was safe under the circumstances. As the two of them walked further through the corridors, the IP repeatedly complained that he was going to trip or fall due to the employee's grip and force, used to push the IP's back and shoulder, moving him forward at a more deliberate pace. Upon reaching holding cell J4, with the IP's legs still chained and his hands still crossed waist chain, the employee used both hands and pushed the IP forward further into the cell. The IP stumbled forward and fell, hitting his head forcefully on the wall in front of him where a bench is located, running the length of the cell, wall 1, then slumped to his right, the back of his head striking the wall perpendicular to wall 1. He was left lying on his right side, his head against the wall, against wall 2 and under the bench. The result of the blows to the IP's head resulted in a serious injury to his head and neck. He was transported to the hospital where it was determined that he suffered from a posterior cervical compression. He ultimately underwent surgery to address the injury, requiring a fusion of his C2 and T1 vertebra, resulting in a months-long hospitalization. On January 30th, 2025, a federal grand jury issued an indictment charging the employee with 2 criminal counts. The first count charged him with a violation of Title 18, United States Code S-242, alleging that the employee deprived the IP of his constitutional right to due process of law under the 14th Amendment. The second count charged the employee with making a false entry in his incident report with the intent of impeding, obstructing, and influencing the investigation and proper administration of the investigation. On January 31st, 2025, a sheriff's lieutenant personally served on the employee the proposed order of immediate suspension. The lieutenant, reading from a prepared script, informed the employee of the nature of the proposed order and asked the employee if he had any response to the proposed order. The employee did not provide any response, so the lieutenant then served him with the order of immediate suspension. Conclusions. Employee is guilty of failure of good behavior in his transport of the IP from the court holding cell on the 12th floor of the courthouse to the holding cell J4 in the courthouse basement, including shoving the shackled and leg-restrained IP with unnecessary force inside the confines of holding cell J4, such that he suffered serious injury to his head and neck. Employee is guilty of acts incompatible with and/or inimical to the public service in failing to provide the IP with respect and compassion and failed to provide the department and the public with honesty in his reporting of the incident. Such conduct resulted in a very serious and public prosecution by the U.S. Attorney's Office, alleging violations of the IP's rights guaranteed under the 14th Amendment of the Constitution. Finally, it is determined that the sheriff's determination that emergency circumstances exist and that the employee's immediate suspension is essential to avoid harm to the county or to the public was appropriate, and that the department followed the necessary procedures to invoke Civil Service Rule 7.2.1b. Level of discipline. Civil Service Rule 7.2.1b allows the department to immediately impose discipline through removal if an emergency exists and the department finds it is necessary to avert harm to the county or to the public. Certainly, the federal indictment and subsequent prosecution by the United States government creates a serious enough situation to remove the employee from his assignment until he is either adjudged innocent of the crimes with which he is charged or is convicted. Whether acquitted or convicted, the department has reserved its right to make a final decision on any discipline. Regardless, it is enough that this hearing officer finds that the department has met its burden, proving that the conduct of the employee was such that the interim suspension without pay while the resolution of criminal charges remains pending is appropriate in order to avoid harm to the county and qualifies for the exemption set forth in paragraph B of section 7.2.1 of the County Civil Service Rules. Recommendations. Based on the findings and conclusions set forth above, I hereby recommend the following decision: that the order of immediate suspension be affirmed, and 2, that the proposed decision shall become effective upon the date of approval by the Civil Service Commission, and I so move.
Is there a second to Commissioner Coleman's motion?
I second.
A motion and a second. Would the Commission Secretary call for the vote, please?
Commissioner Bassett,
Aye.
Commissioner Coleman,
Aye.
Commissioner McGovern.
Aye.
Commissioner Montenegro,
Aye.
Commissioner Rodriguez Kennedy.
Aye. Motion carries 5-0. Commissioner Coleman, thank you, and I will return the chair to you.
Thank you, Commissioner Montenegro. The results were unanimous, and thank you for chairing this portion of the meeting. On to agenda item 6, which is 7. Okay, where's 7? There it is. Our next discussion item is agenda item 7 regarding a request to seal a performance appraisal. Staff's recommendation is to deny the request. As a reminder, please refer to the employee as employee or the case number we assigned 2025-040. We will give the employee an opportunity to speak, then we will allow department's representative to respond. You will have up to 5 minutes each. I understand that you might need a little bit more time. How much is a little bit more? Are we okay with that? If you can, that would be great, because we started late today. So it's not your fault that we started late, but we did. All right, thank you. And so now the employee, is the employee here? Okay, thank you.
Okay, we have a chair there that you can sit at and make your presentation to the commission. Afterwards, the department will have an opportunity to respond. So just a reminder, do not mention the employee's name. Yeah.
Okay,
But she should identify herself.
yes, okay.
Yeah, please.
So the employee can identify yourself. No.
The representative
Counsel.
can identify herself, but please don't mention the employee's name.
Thank you. My first time here. Okay.
My name is Leah Peer and I'm counsel for the employee 2020
Last name? How do you spell your name?
LEAHPEER.
Thank you. You may continue.
The employee here, an animal control officer, requested to seal her performance appraisal covering the period of April 4th, 2024 to April 3rd, 2025 under full, predominantly for procedural flaws which caused her harm. The DAS essentially acknowledged the late issuance of the appraisal on or about June 6, 2025, and also admitted to the commission in its response on November 3rd, 2025, that the appraisal was missing required signatures of both the employee and the rater in violation of Rule Section 5.1.1. The department cited their belief that the appraisal was still timely given the employee's multiple medical leaves, absences, and temporary work restrictions. While the commission may find good cause when there is a complete absence from duty while an employee is on medical leave, such is not the case here because her treating physician and the DAS approved her to continue to work for the county at a different work site at the medical examiner's office as a reasonable accommodation from May 15th until June 6th, which was then extended through August 2025. Therefore, the good cause exception for an untimely, unsigned appraisal should not apply to the department's procedural violations. If you are still working with an accommodation, even at a different work site, the department
Speak into the,
manage the appraisal process.
excuse me, I'm sorry to interrupt you. Could you please speak into the microphone?
If you're still working with an accommodation, even at a different work site, department is still expected to manage the appraisal process on time. Here, the employee's approved medical leave began April 1st, 2025, just 2 days after the appraisal rating period. Her supervisor at the time, Lieutenant Jackson, made no attempt to meet with her prior to the end of the rating period. However, he did manage to meet with her while she worked at her accommodated job at the ME's office. The employee was out continuously on disability leave from April 1st through May 6th, 2025. But she was approved to return to work with a temporary work restriction, which precluded her only from working at the DAS. While approved to work at an alternate work site as early as May 6th, the department was not able to accommodate the employee with placement at the medical examiner's office until an interview on May 12th, 2025. On or about May 15th, 2025, the employee began working full-time, Monday through Friday, from 7:30 a.m. to 1600 at the ME's office. The employee remained working there from May 15th through June 6th, which was extended by her doctor through August 2025. So contrary to the department's assertions, the employee was available at all times during these work accommodation periods to meet for a timely performance appraisal with supervision at the ME's office. The department's argument that the employee was on continuous leave through June 6th, which delayed delivery of her performance appraisal, is false. Senior HR Officer John Aduti had regular communications via email and telephonic with the employee, not only during the entirety of her medical disability leave period from April 1st through May 6th, but consistently throughout her accommodated work periods at the ME's office from May 15th through August 2025. While working at the ME's office, the employee also had meetings with her supervisor, Lieutenant Jackson, HR Officer John Aduti, and Director Von Maurice. These meetings and constant communications were so distressing and contradictory to the work restrictions imposed by her doctor that the employee reported these issues to the Office of Ethics and Compliance and the California Civil Rights Department as discrimination, continued harassment, and retaliation, which are still pending investigation. At issue here, though, is the performance appraisal received by the employee on Thursday, June 5th, 2025, which was emailed to the employee at 16:47 hours after the employee's scheduled work shift ended at the ME's office. The email was sent by the employee's second-level DAS supervisor, Rachel Borelli, with the subject header, Employee Performance Appraisal Report for employee 2025-040. The email stated, I am sending this as your supervisors are off today. It is a draft. You have 5 days to review. Thanks. Contrary to the department's assertion, there was never any discussion about meeting with the employee about the appraisal on June 6th or June 7th. Ms. Duty did call the employee to confirm she received the appraisal, and the employee advised her she wished to appeal. Ms. Duty told the employee not to take it so hard. It's just a piece of paper. The employee became physically ill after that and had to leave work, reported to the Kaiser ER. The employee reported back to work at the ME's office on June 9th, 2025. Senior HR Officer John Aduti again called the employee while she was at work and advised that if she still wished to appeal, that she was required to sign the appeal portion at the bottom of the appraisal and send it back to Ms. Duty, although the employee acknowledgement and rater areas remained unsigned. The employee sent her signature for appeal to Ms. Duty on June 9th, 2025 at 1:56 p.m. via email. The employee asserts that the responsibility to issue a timely appraisal with required signatures lies with the appointing authority or her supervisor, and this applies even if your regular supervisor is at a different site, and they are still required to facilitate the meeting and provide the appraisal document with required signatures within that 30-day window. They failed to do this, and the employee was not unavailable as asserted by the department. Under Rule 5.1.7, an appraisal missing required signatures may be categorized as improperly issued. This is a flaw in the process that gives the commission grounds to intervene by sealing the record, because it further violates the systematic method of recording and communicating performance as intended by Rule 5.1.1 to protect authenticity and verification. A copy of the written appraisal is to be provided to the employee with the rater's signature already present at the time it is given to the employee, and standard county procedures also require the rater to discuss the appraisal with a reviewer before presenting it to the employee, and this was never done. An unsigned original appraisal creates a procedural break in the chain of accountability. If an appraisal is issued without signatures or outside that 30-day window, it fails the systematic requirement because it lacks the necessary procedural safeguard to be a reliable and authoritative record of performance. The department also failed to appoint an unbiased appeal officer. Therefore, the appraisal process was procedurally deficient. On July 7th, the employee was provided 3 names and selected Appeal Officer Manuel Balcazar. On the date Ms. Lee was to meet with Mr. Balcazar with her union rep failed to appear, but Mr. Balcazar wished to proceed. The appeal meeting lasted approximately 30 to 40 minutes. The employee came prepared with numerous copies, for Mr. Balcazar of a written summary outline and supporting documentations which refuted items line by line within the appraisal. Mr. Balcazar initially only wished to speak on a highly personal level with the employee, candidly expressing his own fear and deep concerns regarding retaliation by DAS upper management. Mr. Balcazar also specifically stated that there were days that he would drive to work and would sit in his car and dread walking in. The employee listened uncomfortably until Mr. Balcazar finished and was ready to hear her appraisal concerns, which he allowed a shorter period of time for. After taking scant notes regarding a few of the employee's concerns, she tried to give Mr. Balcazar her documents, believing he would accept them for a full review. However, he refused to accept them. He even refused to take the summary itemization document arguments that she had prepared for him. Mr. Balcazar only stated to her that he had what he needed. The employee felt confused and concerned. On August 20th, 2025, Mr. Balcazar issued his report recommending the removal of only 1 sentence in the performance appraisal, but otherwise upheld the overall disputed low rating. The appointing official, Director Maurice, agreed with the recommendation. On August 21st, the employee wrote an email to HR Officer John R. Duty requesting an investigation into the appeal officer's conduct and statements during the appeal meeting and asked for a new and unbiased appeal officer. Senior Officer John Duty advised that she would consult with the OEC on the employee's concerns, but she has yet to hear back. Finally, the employee was sent a copy of the final appraisal, signed by the HR officer, John Duty, without the employee's knowledge or her consent. Specifically, on August 20th, 2025, the employee received an email from Senior Officer John Duty advising the employee of the appeal officer's final decision and recommendations with a copy of his report and agreement by the appointing authority, Von Maurice. The employee was advised that a final performance appraisal had been prepared for the 2024-2025 period and was included as an attachment. 1 sentence was removed, but the employee was still not asked to sign or initial that final appraisal. Instead, the employee's signature appeared on the final appraisal, still in that appeal section, in HR John Duty's handwriting and backdated to June 30th, 2025. This was done without the employee's knowledge or consent. In addition, the final appraisal contained the signatures of the rater, Georgina Raygosa, backdated to June 9th, 2025. And the reviewer's Assistant Director Rachel Borelli's name was included, backdated to June 5th, 2025. These dates are inconsistent with John Duty's response to the commission dated November 3rd, 2025, wherein she stated that the DAS worked with the employee and Raygosa in obtaining remaining signatures on June 30th, 2025. All signatures and dates appear on the final appraisal to be in the same handwriting, which the employee recognizes as that belonging to John Duty. This appears to be yet another procedural violation of Civil Service Rule 5, Section 5.1.8, which provides that any changes to an appraisal must be initialed by the employee, the rater, and the reviewer. Again, an unsigned or forged original appraisal creates a procedural break in the chain of accountability, authenticity, and verification. The employee here was deprived of a fair and timely chance to correct the disputed performance issues, which is a protection explicitly supported by March 2024 minutes of the Commission. Without a procedurally correct appraisal on file for that 2024-2025 period, she is also ineligible for promotion in place or other advancement opportunities within the DAS per Human Resources Manual Section 1208. For all the foregoing reasons, the employee respectfully requests that the Commission reconsider its recommendation and order the preparation of a new appraisal, or that the appraisal be sealed with all accompanying documents. Thank you. The employee is available should you have any questions. And these were the documents presented to the appeal office of Balcazar, which she refused to take possession of.
We do. Oh, does the department have a response?
Good afternoon, Commissioners. My name is John. Sorry, now you can hear me better. My name is John Aduti. I'm a Senior Departmental Human Resources Officer with the Department of Animal Services. Employee 2025-040 is requesting to seal their performance appraisal. They're asserting that this was issued late. The performance appraisal rating period did end on April 3rd, 2025, as you know, is inclusive of rating that employee through that period. As the employee's representative stated, she went out on medical leave starting on April 1st and continued to be out on medical leave until temporary accommodations could be identified with the medical examiner's office, which did start on May 15th. I do want to make a side note on that. There is a typo in my response. It says the 19th. It really is the 15th, and that was brought to my attention today, so I want to apologize for the typo. But even with her returning to work on the 15th, the performance appraisal was issued electronically on or around June 5th, June 6th of 2025, well within that 30-day time frame that is required per the civil service rules. The assertion of the missing signatures, the rater was not able to sign the electronic performance appraisal because they went on days off, so they physically were not able to sign it. The reviewer instead had signed electronically the performance appraisal, and was why they had issued it. Again, the concern was making sure that the draft performance appraisal was issued timely. And as you're also well aware, the employee has 5 days to review and consider, provide feedback, suggested edits and changes that they'd like to see. And instead, I received an email from this employee on June 6th requesting to appeal their performance appraisal. Now, while they attached a performance appraisal, it was an unsigned one, so there was no employee signature in the appeal section. But recognizing that this employee had in fact requested the appeal, we wanted to honor that. And while the employee did then go out on leave again, when that person was able to come back, we were able to get those signatures to then start the appeal process. I would also like to mention that the temporary work restrictions exclusively prohibited this employee from working at the Department of Animal Services. So there was a medical bound barrier that prevented this employee from going on to DAS property, into DAS offices, doing any Department of Animal Services work. And that's how we were able to find an accommodation through another department. The respondent had also mentioned that there were continuous meetings, that this person was available, in fact, had many meetings with multiple people. Those meetings were to address their temporary work restrictions, which were required to comply with under the ADA. This employee had also initiated a grievance. And so in order to follow that grievance process, it necessitates and requires meetings as well. And then again, the performance appraisal appeal. Again, these are all requests that are initiated by the employee that we are complying with in accordance with all the rules and regulations and policies. This employee also had multiple opportunities in order to provide documents, their feedback, suggested changes at multiple points, whether it's through the initial time that they were emailed a draft, and then all the way through the performance appraisal process. As the employee's representative also said, this employee requested a name of 3 appeal officers, which were provided, and this employee selected their appeal officer. I will note that one of the appeal officer candidates is not an employee of the Department of Animal Services. So and none of them are in a normal chain of command. And we feel that we're all unbiased. The comment about the appeal officer being afraid of retaliation under management did not come and was not reported until after the results of the appeal officer's recommendations that had been approved and revised and then sent out. So it wasn't until this employee received their revised final performance appraisal following the appeal that they then reported this concern. That concern was taken very seriously. I personally met with the appeal officer to see, is this in fact true? And I did make a referral to the Office of Ethics and Compliance. And to this day, I still have not received anything from the Office of Ethics and Compliance about it. But we did take it seriously. We did address it. This appeal officer denies that allegation wholeheartedly. But we did report it in accordance with county processes. And then final, I want to address 2 more things. One is the backdating of the signatures. Now, our performance appraisal form is electronic signature, and it's really hard to capture when the original signature dates electronically, because it will only make it to the current date when the person is signing. So the procedure has been, and for many years, is that when we issue a finalized performance appraisal after the appeal is completed, the appeal officer will sign digitally in the appeal officer section, indicating that the appeal has been completed. And then we capture those same signature names and dates on the form, and a lot of times we have to handwrite it. So that is my handwriting on our final performance appraisal. And then the last thing about this employee asserting that it makes him ineligible for future promotions and other job opportunities. I don't agree with that. A performance appraisal, no matter what the state is, the fact that they appealed is not a negative indicator of their opportunity for any future county position. You rely on the content, you rely on how long it is, and every department makes their own decision as to is this a fit for them or not. So it doesn't make them inherently ineligible to apply for or be considered for future promotional opportunities. If you have any other questions that you'd like me to answer, I'm also free here in order to answer.
Now that we've heard from both parties, do any of the commissioners want to ask a question? Do you want to ask a question?
Okay, so I think this is more for the appellant or respondent. Is the respondent?
The employee.
The employee, and actually the employee's counsel. Could you come to the?
And make sure to speak into the microphone, please.
Brass tacks. What are your procedural accusations or allegation? What is the procedural? Do you have the timeliness, obviously?
Timeliness,
Okay.
failure to have required signatures in place.
Yep.
Also the biased appeal officer, so deficient procedural appeal process. And the 4th one is violations of 5.1.8, which is making changes to the appraisal without notifying the employee in advance and obtaining the initials of the rater and the employee on the final appraisal. Therefore.
Okay, so in terms of the signature element where the signature is backdated, describe that for me. What are you suggesting here? Well, obviously it's backdated, but why? Like, why would the department, how would that serve the department?
To me, it's fraud. Okay. It's misrepresentation. It's a false document contained in the employee's file and should be pulled. If management has the ability to do that, I think it compromises every single item within that document, which is the employee note that the appraisal was sent as a draft to the employee for review. She was never given the opportunity to have a meeting with any supervisor to challenge the disputed items within that document. Now, Ms. Duty admitted that there were meetings at the ME's office with the employee during her accommodated period. They were able to do that, but they couldn't have an appraisal meeting with the employee to discuss any perceived deficiencies. But and she claims that they were related to her accommodation. No, they were not. They were related to grievances that the employee had when they issued her a disputed letter of warning, an LOW, which had to be withdrawn by the department on July 3rd, 2025. That was the one sentence that had to be removed from her performance appraisal. That was the only thing that was removed. The other material items within the performance appraisal, whether there were issues that were related to that LOW. And we know we can't go into the substance of things, but there were not only substantive problems with that performance appraisal, but there were numerous procedural issues with that performance appraisal. Why issue it after hours at the ME's office and not give her an opportunity to meet with her supervisor at the ME's office when her supervisor met with her on May 15th at the ME's office regarding the LOW? They can meet with her regarding discipline, but they can't meet with her regarding her appraisal.
Can I ask you a question? What you were asking for one of two potential remediations. What were those two? One is obviously to seal the performance appraisal. What was the other one?
Order a new appraisal be provided.
I'm going to yield to the other commissioners who may have questions for you, but I'm going to want to hear from department after this.
Are there any other questions before you leave? Any other questions for the employee?
I had the same concerns as Will. I'd like to hear the response to some of the issues that were presented.
I have a question before you sit down.
All right, there is one.
Is there one?
I must be shrimpy here.
I just want to clarify what you're asserting would be the difference if a new appraisal was ordered. What opportunities were missed, or your client was deprived of what opportunities or rights through this process, other than the procedural deficiencies that you described? What's going to be different about a future process?
Every opportunity afforded to an employee to fair meetings with supervision to address any perceived deficiencies regarding performance. Meeting in advance, discussing what is wrong in advance, to be giving notice and opportunity to correct, to having a meaningful exchange regarding any perceived deficiencies. Civil Service Rule 5 provides that employees are not to be caught unaware and surprised. She was blindsided after hours with this email and not given any opportunity to respond. At the time that it was given to her, she was really not even afforded the full 5 days to respond. There were no signatures. Even the dates are wrong. If you take a look at the final performance appraisal, then the the dates don't even make sense.
Was there an actual denial of requests to discuss those things with the supervisor?
Never.
So the department never denied a request for your client to discuss it with her supervisor?
Miss Duty alleges in her November 3rd, 2025 response that there was an attempt to, or a hope to meet with the employee if she returned to the DAS on June 7th, 2025, but there was never any discussion about that in the telephone call between the employee and Miss Duty on June 6th when they had a telephone conversation. And they had several telephone conversations. There was never any attempt to schedule a meeting, and the employee would have welcomed that.
Did the employee ask for that meeting?
Yes, she was on, she met, one of the meetings we actually had was because they wanted to get information on something I don't know if I'm allowed to say, but there was an investigation going on with another employee, and they met with me for about an hour for information in regards to that investigation.
Did you ask at that point if you could have a meeting?
Yes, I also asked for the support for the EPAR, for the negative EPAR. And I feel like we're also focused on these after dates. Remember, this EPAR is from 2023 to 2024. You had a whole year to meet with me. There's not one positive thing in the EPAR. Not one time did you guys go, hey, you know, there's going to be a negative EPAR coming up. Let's get together. Let's make these changes. Let's fix it. But now that April 4th comes, it's like cut off. What about the rest of the year? I didn't go on medical leave until April 1st, 2 days before the EPAR ends.
Are you suggesting that the things that were identified or documented,
Speak in the microphone.
identified as, being lacking certain performance criterias were never discussed or brought to your attention at the time?
Absolutely not. Nope, they were not. And the person that is responsible for this EPAR also wrote my very first EPAR. He refers to me as a different officer in it, as Officer Sands. He also puts the incorrect rating on the EPAR and forgets about the whole 3 months of my employment there.
So you're suggesting that when you read these issues that were documented in the appraisal, performance appraisal, those were the first time that you had ever been
Yes,
aware of these issues?
absolutely. Yes. I was in shock. I couldn't believe it. And I couldn't find one good thing on there about me. Very disappointing. I've worked for the county since 2020. I started off as a code enforcement officer. I also worked in the sheriff's department and promoted very quickly to working in as a detention processing technician in the jails at Las Colinas in the sheriff's department. And I have never experienced such retaliation, such negativity. I mean, I have to toot my own horn when I say I'm a great employee and I'm a rule follower. So getting this was devastating.
Thank you.
No other questions for the employee? All right, thank you very much.
You guys, I appreciate your time.
And now we'll hear from the department again.
Afternoon again. John Duty. Just to respond on a couple of the comments that the employee and her representative had mentioned. May 15th was a day that was her first day back, but that was at the medical examiner's office at a different department. The temporary work restrictions, like I had mentioned before, explicitly said this employee cannot go onto DAS property, cannot do any DAS work whatsoever. Those initial temporary work restrictions were from May 9th until June 6th, or excuse me, June 7th. So they were through June 6th. That's why the department had the expectation that maybe she'll come back on June 7th. June 7th is within the 30-day time frame of when she returned from her leave of absence, and then we could meet with her in person. That was the intent. However, on the 6th of June, earlier in the day, this employee provided an extension of those same work restrictions that went through August 31st. So recognizing that the department was prepared, had a draft, we wanted to make sure it was issued timely, as quickly as possible. Again, affording, even it says in this, the representative's comments that they were, hey, you have 5 days. This employee responded within 24 hours saying, I want to appeal. That's their right and their decision. That is part of the checks and balances that our civil service rules allow. And so knowing that that was their decision, we honored that decision. Granted, they didn't sign the actual form in order to start the process till much later, when I did meet with this person on a different matter that they were involved with. And so since I was meeting with that person and trying to, as we wear multiple hats into making sure multiple processes are done to capture that signature, there was some technical issues. That's why they couldn't sign it electronically. And again, just going on the backdated dates, it reflects the dates that the rater and the reviewer and the employee initially signed the original performance appraisal. So that's why those dates are backdated.
Just one clarification, mostly for me.
Sure.
When you've said it a couple times.
Yes.
That, during this period of time when she was on light duty or accommodation, you're unable to talk to her or meet with her with anything having to do with DAS. Is that correct?
Correct. That is animal services work. Yes.
So what you're saying is, even providing the appraisal or the appraisal review, the performance review would qualify as conducting.
So that's county business. I would consider that county business, as it's under the civil service rules. It's not a DAS policy. Like I said, we had intended on issuing the performance appraisal in person. And, it says in the DHR policy, the guidelines recommend that you issue them in person. And of course, that is the gold standard. That's not always the case given people's vacation schedules or regular work schedules. In this department, we have staff that work 7 days a week, 24 hours a day through holidays and all kinds of weather. So sometimes supervisor schedules are on different days. And at the time of this particular issuing, the main supervisor that she was discussing was on vacation. That's why there was also another supervisor who's at the same level that issued it. And that's why the reviewer had signed, because they were out on vacation. They wouldn't be back within the 30 days.
Is the appeal process where they get to do a rebuttal, or can they do a rebuttal before the appeal process, or is that not?
So the process is that when the draft is issued, the employee within the civil service rules says that they have up to 5 days to consider the drafted performance appraisal. That is their opportunity to say, hey, supervisor, I'm missing this special project that I'd really like to have highlighted. I don't agree with this rating. I don't like this wording. I'd like to have it changed. That's an opportunity for them to work it out with their supervisors. They could have requested a meeting, had there, like in this case, there was not a meeting normally that we would issue that. But she had already decided she wanted to go through the appeal process, but she could have done so. And then again, during the appeal process, that's where they can, again, bring to an appeal officer all of the documentation. They can say what don't they agree with, what do they agree with, what they'd like to have included, and they bring forth that information. Of course, again, the appeal officer can only consider things within the rating period that they are reviewing. And that's what was done in this case. So there was multiple opportunities in order for this employee to provide their feedback. And I did want to touch on one other thing. I know you didn't ask it, but it was something that was said, is that this employee felt they were being blindsided, that they had no meetings whatsoever. There were meetings. There were, and those meetings and those observations were documented in the supporting documentation that was provided in with the packet in the response to this request for seal of appraisal.
And you have that documentation, you keep it for a year or till the appraisal is completed, or where does that?
So supervisors keep their documentation in their supervisor file for the rating period. And then once that performance appraisal has been finalized and filed, they should be getting rid of all that documentation and having a fresh start. They should only be looking at the current rating period. Now, as an HR person, I have my own HR records. I keep copies of those performance appraisals and the appeal process. In case there is a question, there is documentation of the process. And again, that's my role as a senior DHRO, which I'm the only HR person for my whole department, so I wear a lot of hats, is making sure that did that procedure comply with the civil service rules. And again, I'd like to attest that in this case, this appeal process did comply within the civil service rules, as well as the issuance of the performance appraisal.
Madam President, oh, sorry. Chair, you-
When that documentation was issued, those opportunities where someone sat down and said, here's where you didn't perform appropriately, do they get an opportunity to initial that or get a copy of that?
So there's a variety of documentation, and in this case, some of it did include emails between their supervisor and this employee. So they would have had a copy as they were emailed into that. Others are like noted observations, maybe on specific activities that they had throughout the rating period, notes of commendation. It's a variety of things. As part of the appeal process, they are required to get a copy of all supporting documentation that was used in the preparation of this performance appraisal within 5 days of the appraisal appeal process being initiated, and that was done. There is also observations that supervisors could make that they would also be attesting to, which is why the appeal officer would have met with this employee's supervisors.
Madam President. So as I understand it, you testified that you took a complaint seriously and referred it to the Office of Ethics and Compliance.
Correct. I investigated it myself and also made a referral.
That was the appeals process.
That was
hearing.
the allegation about the appeal officer that this employee made, is that the appeal officer was afraid of retaliation from management.
And what was the content? Like, what was your basis for referral?
Well, they were alleging retaliation. If
You
this
just forwarded
employee,
on.
if this other employee is alleging that another employee is being retaliated against for the service that they did as an appeal officer, that certainly wouldn't comply with county rules. Or
What did your investigation determine?
so I met with the appeal officer on 2 occasions, and I asked, did this, in fact, did you say this to this person? Was there any inference or did anyone pressure you to or give any impact into your assessment or determination of the recommendations of the appeal? And this appeal officer said, absolutely nobody made any inference. They were not afraid of management. It was quite the opposite of what this employee is alleging. I really tried to probe this person to say, like, is this true? Is it not? Because if it is, it's very serious. And they denied it. And so I reported that information to the Office of Ethics and Compliance, as well as the concern that the employee brought up.
So you did not find evidence of that.
Correct. There were no other
allegation.
witnesses present at that meeting, so it's.
But you referred it anyways? Is that the
I
point?
referred it anyways.
Okay, out of an abundance of caution.
Well, we're required to, but yes.
Okay, so it's required. That was trying to.
Required to.
Yeah, okay.
But
So-
yes.
You're required to refer it even.
Absolutely.
Okay.
Even if I find a determination, like, it doesn't stop the department from looking into areas of concern.
Sure.
We would also look into, as this allegation is very serious in nature. But
the,
yeah,
the employee alleges that states that their union representation was not present and that they went forward with the hearing anyways. Is that the normal practice, or?
so I was not present at any of the appeal officers' meetings, so I can't personally tell you, but we would always allow representation during an appeals
So
process.
if representation wasn't present,
Sure.
what would happen?
if someone came to me in that situation as the senior DHR, I would say, well, does the employee want to have representation? Because oftentimes we have employees who don't want representation. They feel they can represent themselves and they want to pursue and move forward. And if they weren't comfortable, we would reschedule it. Or I would encourage the appeal officer to reschedule to a time when they would have representation present.
And so what are we alleging at this point? Do we think that the employee was going to wanted to pursue the appeal without union representation?
So this employee had representation throughout the process. So I would have expected that they would have had representation. I'll be honest, like this is the first time I'm hearing that they won't have that they didn't have representation outside of when they alleged after the appeal had been completed.
So we are under of the understanding that they did have union representation afforded.
Absolutely.
But you did conduct an investigation. We know that the only two people that were there were the employee and the appeals office, hearing officer.
Yes.
So we are noticing an absence of union representation. So, and the employees alleging that they wanted union representation, right? So that could, so do you think that maybe that's a basis to like take another look at it?
I mean, if the employee had said, hey, I normally have it, but I feel comfortable with you and I want to move forward. Like I wasn't there, so I'm just projecting and surmising what could have happened. You know, that to me seems like that a process was still complied with and afforded. Certainly if it's something, if you can give me back, I could go find out if that was the case.
Okay, we're way far. We're off base at this point. But my question for you is, would it be some form of hardship to look, sealing an appraisal is one thing. It's kind of serious. It's rare that the commission does it. One of the options that they're requesting is to have the process redone. Would that be a hardship to the department to do that? I mean, taking another look at this, would that be bad?
You know, even I'm reminded that even after the appeal process is over, there is a section in the civil service rule that allows for changes to be made to a performance appraisal after it's completed. And that's where it requires everyone's initials to that document. So that is always an option post-appeal, that if there was something in particular that that was to be changed, I mean, all parties would have to agree to it, but it could be.
Or we could order it. Great.
Again, you're looking at content too, so.
I'm looking at, I know what I'm looking at, but thank you. I appreciate you. I have no further questions for the department.
Okay, quick
I'm sorry.
question.
Yeah.
Don't be sorry, it's okay.
And I'll be quick. When you reported to ethics and compliance your findings,
Yes.
is there a follow-up on their part? Is there a follow-up on their part to your findings, or do they conduct their own investigation?
So my understanding is they will review the received allegations or the complaint. They determine if they are going to conduct an investigation or not. They have their own requirements of what they are willing to investigate or not. Oftentimes, I'll be honest, in my experience, a lot of times I don't hear anything. Sometimes I've gotten referrals back that says, no, we're not going to investigate it. It doesn't comply within our investigative parameters. And we're going to refer it to the group office, in this case, the public safety group office, or back to the department to conduct an additional investigation. Obviously, I conducted my own informal investigation. And so I have not been notified if it was ever referred to the public safety group HR office or not. I normally don't get included in that unless it gets referred back to me or there's some formal investigative report or action.
So my last question, and I apologize, right?
That's
I come from an HR background
Okay.
as a director in labor relations.
There you go.
And so my question is, when shop stewards are allowed to be present, right? Do they have to be present when there's going to be an outcome involving time off, layoff? Do you normally have shop stewards present when you do performance appraisals?
To issue a draft of a performance appraisal? No.
How about a final appraisal?
No, in fact, we distribute it based on, again, the civil service rules where it says it's very specific and says the appeal officer's report, the documentation that shows that the appointing authority either agrees with it in its entirety, and then that is then finalized as was recommended by the appeal officer and then distributed, which did include to their representative. There is a provision that the appointing authority, if they didn't agree with the appeal officer's recommendations, then a meeting must occur within 5 days that then gives an additional opportunity for the appeal officer to have a discussion. And that is a meeting with the employee that says, hey, the appeal officer said this, I don't agree with it because of why. And he gives them an opportunity to respond before it is then finalized.
So one quick final question.
Ultimately, the appointing authority makes the decision on it.
And referring to Commissioner Kennedy's question, you had to rewrite the appraisal. It's still going to cover the appraisal period,
Correct.
right? What would change?
Nothing would change.
Thank you.
But they would have an
Draft-
opportunity to.
To appeal it again?
So, okay, let me ask, can I ask, oh yeah, go ahead.
Are you done?
I'm done with the department, yeah.
Okay. So I believe I've heard that the employee's direct supervisor who completed the appraisal was on vacation. So someone else issued.
Co-supervisor. Yeah, this employee is supervised by multiple supervisors at the same level, again, because of the said scheduling things. So,
But the employee never got a chance to meet with either of those co-supervisors. It was all electronic.
Lieutenant Jackson is the one who made all the errors in the previous performance evaluation that to date have still not been corrected.
And that person is no longer with the department. Okay. So
Let's stop. Okay, we're out of order. Point of order.
Okay,
Madam President.
all right. I'm supposed to be in conversation over here. That's all right. So what would change if it was done over is one of the direct supervisors of the employee would actually be having a conversation about the deficiencies that were found, and that there would be an opportunity for the employee to say, I want to change this language, or I want to highlight the things I did well. Some of the things the employee is saying were not in this performance appraisal. You just said nothing would change.
well, looking at the from the appeal officer's report, because again, I'm not the one that prepares it. The supervisors prepare it. Looking at the supporting documentation and that those supervisors have given their input on their observations, I can tell you that there's not going to be any new documentation that comes in outside of, unless there's some new documentation that maybe this employee has that wasn't considered during the appeal process or in that initial 5 days that they could have responded with or provided. Or
And you said that she was not blindsided by these deficiencies, that there'd been several. Is there documentation to that effect?
Correct.
Was it provided to the employee?
they were provided as mandated in the civil service rules after the appeal process has started, but there was documentation. And had this employee requested or wanted to have further dialogue, which we could have facilitated, then those items would have been reviewed with her at that time.
But you don't customarily review deficiencies with employees until they appeal?
No, that's not what I'm saying. I
Okay.
apologize that I misspoke. There is conversations that happen throughout rating periods. There is feedback. There is, like I'd mentioned earlier, that some of the supporting documentation included emails from the supervisor to the employee discussing some of these performance concerns. There are also in-person meetings that had also occurred to talk about some of these performance deficiencies. And then when you are issuing a draft of that performance appraisal, typically supervisors just have the draft in front of them and they would normally meet. Again, that's within the gold standard and within the guidelines of DHR policy.
It didn't happen here.
Correct. And that, again, there were a number of factors that went into that. Now, in the appeal process, again, as prescribed by the civil service rules, she is mandated to receive a physical copy of those supporting documents within 5 days of the appeal process starting. And so that's, I wanted to clarify, and I appreciate you giving me the time to do so.
Okay. And the only other question I have is, there's a question of, just lost it because there's,
Sorry.
no, there's so much to try to keep track of here. Just a second. If anybody else has a question, bail me out.
I have just procedural.
Wait, okay, go ahead. Ask your procedural.
So could we order them to redo this?
Yes, your authority is that if you find that a violation of civil service rules did occur, you can order that the performance appraisal be sealed, and that's it. Or you could order that performance appraisal be sealed and that a new one be prepared without the violations that you identified occurred. So if it was a timeliness issue, which there wasn't in this case, but for the sake of discussion, the person would essentially be getting the same performance appraisal because it would just be, I guess,
We're just having it redone.
Yeah.
So here,
It doesn't really.
are you ready with the question? Because otherwise I have a motion. I can probably move something.
Okay.
Look, so there's some questions here about the appeal process. The representation wasn't there. I don't agree with the argument about timeliness. I think the sort of the time in which the employee was out on was it medical or protected leave, sort of muddies that up. But there are some questions about the signatures. There's questions about the appeals process, and because they're just questions, I think it probably could be in the best interest that we just look at we just do it again. And if that doesn't change the department's position, but it does give the employee the opportunity to have have their day in court hearing or whatever, that might just be better for all of us. That we may come to the same conclusion, but it's a fair thing to do it. So I would find that the procedural problem was with the signatures, which are unclear. Look, putting different dates on the signatures, that's not a good practice. I don't know what that practice is, but that's a weird practice that we need to change. And then also the absence of union representation. There's no waiver or anything language that we have to suggest that the employee just allowed or waived their union representation rights. Like I have nothing about that, and they are entitled those rights. Those would be the procedural findings that I would make. I think they would be fair. Would that be something I can move?
Commissioner Kennedy.
Yeah.
To clarify.
Yeah.
Right, is there a requirement to have a shop steward present during an appraisal?
Not the appraisal, but the appeal.
And there wasn't one.
But
The practice is to allow representation during an appeal process.
An employee has a
process.
who makes that request?
The employee does.
And did the employee make that request in this situation?
So the employee had engaged with representation at the initial time when they initially requested their appeal. I had confirmed with them that they had intended to have representation through the appeal process.
See, that's fair. The employee has rights to union representation. That is a fundamental right. and for whatever reason, I don't think they denied it. I don't think they attempted to do that, but the union representation was sick or whatever, they weren't there, and they proceed forward. When that type of thing happens, like this probably should have been rescheduled, and they should have had their chance to appeal with representation, because then the employee is going into the situation without representation, and the representation is the subject expert about the different policies that sort of like represents them in the adversarial or the interactive process. So I would say that the procedural violation is that when representation wasn't present, that they didn't reschedule, and that, and maybe just leave it at that, because I don't even want to get into the weirdness of the dates. Would that be enough?
Well, it's entirely up to your commission. What is enough of a procedural flaw to warrant sealing and preparing a new appraisal? There's nothing in our rules that mandate that, oh, this type of procedural flaw you must seal, or this type of flaw does not require sealing. So it's entirely up to your commission's discretion as to whether or not first of all, you do need to find a violation to order that the performance appraisal be sealed. And so
if you allow, my motion would be the absence of union representation indicates that the department should have that they, more likely than not, they should have rescheduled the appeal hearing so that the representation could be present. That would be the procedural finding that I would make, and that I would move to have them to seal and redo it.
We have two choices.
Madam President, I still have a question in here.
it would be the commission may also that it be sealed and that they order a new appraisal be prepared.
Okay, so this is just a motion thing. If someone seconds it, then we can discuss it. But like this, in terms of procedure, so I moved that was the finding was the representation not being present and them not rescheduling. My motion would be to seal and order a new appraisal be made. That's my motion.
Is there a second so we can have some discussion?
I believe if there's a second, it's going to cut off my opportunity to ask questions potentially unrelated to that.
Oh, okay.
Okay, I will yield. And yeah,
Because I remember my question.
Go ahead.
And before I forget it, you said something about, or the employee said that you met with her several times at her accommodated site.
Yes, there were a number of items that the employee had requested that as a department and an employer were obligated to respond to, like the performance appraisal appeal. On a different topic, there was a grievance procedure. And then
I don't need to hear all that. My question is more specific. It's, am I understanding correctly that you could not meet with her at an alternate location to discuss her performance appraisal, or no one from the department could meet with her at the place where she was working because it would be doing business of DAFs, or did I misunderstand that?
No, so it's just with the Department of Animal Services. So to answer your question, could somebody have come over to an alternate location other than a Department of Animal Services building location, whatever? Yes, that could have happened. I will again caution, we also had supervisors who were out on various leaves themselves. And scheduling was another issue. And then again, more leaves with the employee, because again, the employee went out on leave again following June.
I'm also concerned that the immediate supervisor that did her review is no longer with the department.
So that supervisor, the contribution that particular supervisor did was in their documentation. I will tell you that they physically did not draft the performance appraisal. The other co-supervisors collaborated and drafted that performance appraisal, which did include the one that was signed as the rater.
For speaking out of order.
Okay. Did you have another question?
It was related, but am I understanding that the normal procedure, a draft performance assessment is issued, then the vast majority of employees the next day could walk into their supervisor's office and say, hey, what is this, and have a discussion with them?
They could, absolutely. They have up to 5 days. And being transparent, if an employee said, hey, I need a little bit more time, or I'd like to know some more, I'd like to look at the documentation used, or I have my documentation, those deadlines of the 5 days can be extended based on mutual consent. And in our department's history, we typically would extend them.
So what didn't happen, well, it seems like there wasn't a request for the employee to have that discussion with the supervisor within the 5 days.
They had decided that they had appealed.
There was also never a denial of that opportunity. Is that correct?
Correct.
Madam President, can we take a 5-minute break? I need to use the bathroom.
Is that agreeable with everyone? That we take a 5-minute break and come back at, wait, Will. Okay, let's come back, please, at 14 after 4. Okay.
No, we're still live.
Huh?
We're still live.
Okay, we're still live?
Yes.
What's that
We're
mean?
in a webinar right now with people
Oh.
that are watching. this.
Oh, I didn't know that.
Yeah.
Okay, so what's that?
Let's- like,
Hurry.
Where I came from. No, where?
Thank you.
Just trying.
We're waiting for Will. Yeah.
I wasn't the only one, huh?
They say we have an interesting mission. I really like all of the persons in the show. Really represent the world.
Every time you guys have a question.
Okay. All right, let's get back to order.
No.
Okay, well, let me call the meeting back to order a few minutes early. At least 2. Are we done with the department? Anybody? No, you're back.
I'm
Okay.
back. Sorry. On the other side, but if we could have just a minute. During the break, sorry, it's John Aduty, just for the record. I was able to contact the appeal officer during the break, and they confirmed that he knew that this employee was represented with a union representative, and that when that representative didn't come, he had offered to reschedule a meeting at a different time to have representation, and this employee declined and wanted to move forward. Also, just on representation, again, as important as it is, it's always best to have representation during procedures like this. The ownership does fall on the employee to request it. It's not something that's required by the employer. Be concerned about precedent and moving forward in that. Certainly, of course, if someone had said, yes, I want representation, and the department had said, absolutely not, of course, I would be concerned about that.
Does the employee get a rebuttal?
Does anybody have any additional questions for the department? No? Okay, and I do believe I saw the employee's representative hand go up. Please be sure to speak into the microphone.
Just a few points
Into the microphone, please.
for rebuttal, and that is on the issue of meeting the employee at the ME's office. On her first day on the accommodation issues, her supervisor, who is no longer with the DAS, Lieutenant Jackson, he actually met with her on the very first day on DAS business regarding a grievance and discuss issues regarding DAS issues. So there was the opportunity, and nothing to do with the accommodation. Also, the the employee also advised that they had no knowledge what happened to the union representative until well after, and they learned that I guess there's a rotation with SEIU representatives, and he had returned back to his normal duties, but failed to advise the employee and didn't show. But the officer, appeal officer, Mr. Balcazar, did not offer her the option to reschedule. That's not true. It should also be noted that Mr. Balcazar works in a trailer with all of upper management, all in the same vicinity. So it has to be very uncomfortable for him to report to work every day after such an allegation. I want to make that point. There was one other issue. Was there something?
Let's stick to the flaws that you're alleging.
There was one other rebuttal.
Lieutenant Jackson had sent me out to the fires in October, and I didn't have any fire gear, and I ended
This
up
is not
filing.
about the procedural flaw.
Okay.
No.
Okay.
Yeah. I believe that's all that I wanted.
All right. Okay, thank you. Are we done with questions?
May I?
There was,
President?
I'm sorry, there was one final note on June 30th, 2025. The appointing authority director, Von Maurice, HR director, our officer, John Aduti, and the union rep came to the ME's office to discuss DAS business, and as an aside, brought a copy of the performance appraisal. And on the appeal section, on that the employee had signed and sent via email to John Aduti. John Aduti had requested that the employee date next to her signature June 30th, 2025. So she had her sign it at the ME's office. So I believe that that is relevant because she came to the ME's office to have her sign the performance appraisal. And that's where that date is, which is inconsistent with the other dates that she signed for the others, as the rater's
Can you
signature
wrap up your presentation with?
is June 9th, 2025, and the reviewers is June 5th, 2025. That's all. Thank you.
I had a question.
Okay.
Madam President,
Whom?
sorry, Dre, the employee again.
Back to the mic, please. Sorry about this.
So previously I asked what would be different. You said that the difference in the process would be meeting with a supervisor. I'm understanding that that was never requested within the normal 5 days, that that would occur during the normal process in the original proceedings of this appraisal. Is that correct?
That the employee never met or
That the employee never requested to meet with employee's supervisor and discuss the draft performance appraisal.
I absolutely requested. And then again, she's mentioned several times that they've been on vacation and are now no longer with the department.
So when was that? I'm understanding that it was sent and within 24 hours, a request for an appeal was made. Did that request for an appeal also include the request to speak with the supervisor, or when exactly and how was this request?
My first question was, who wrote this? Because I don't know who wrote it. There's no supervisor's name on it. Like, I'm in shock. Like, I can't believe what I'm reading, you know? And I'm like, who wrote this? I need to, I need to talk to someone. Like, what's going on? Typically, you guys meet with us prior to, let us know how we're doing, where we're at.
If
That
I
never
may,
happened.
I'm asking when exactly was the request to speak with the supervisors made?
6.
And
The-
how was it made?
By phone. Phone call with John on duty.
yes, she was working at the ME's office. The email had come in on June 5th via email. She was scheduled to work back at the ME's office on June 6th. When she arrived, she sees the email, was blindsided. I believe she contacted her union representative, was advised that she would need to appeal. John on duty, who was on vacation at the time, contacted her. She verbally advised John on duty that it was her desire to appeal. John on duty told her, well, I'm on vacation right now. Don't get so upset. It's just a piece of paper. And then the employee did request, well, I want to meet with the supervisor, and I'd also like to see the documents and the information that supports what I'm seeing in this appraisal. Miss Duty also advised the employee that she would not be able to see or have access to any of the documents until the appeal process started.
And she advised me that she was placing me under investigation for a serious allegation that was later misfounded.
Just stick to the performance appraisal.
Okay, any other questions? All right, I think we're done with our questions. We have a motion on the table.
Oh, wait. Oh, yeah.
you
I
wanna
mean,
read-
now there's a bunch of different things.
You want to modify your motion?
Well, I don't think that we actually
Have a motion?
got to. So, look, yeah, it didn't get seconded.
No,
What I'm struggling with,
it never
is-
got seconded.
it never got seconded. So what I'm struggling with is what I would find, and
Yeah.
that's
That's why the staff recommended deny request, even with the additional information that we've heard today. So to find something to latch onto that would be a violation worthy of completely wiping out a performance appraisal, potentially ordering a new appraisal. We just did not, in our findings, see a violation like that would warrant that. But that's up to your commission to determine that.
and based on a finding, is a finding like we're stating that as an actual fact, or we're saying more likely than not? What is the basis of our finding? What is the burden or the standard of proof?
It's if you determine that there is a flaw, then, and you vote for that, then you've determined that there's a flaw. I mean,
Okay, so what I would find if I were to try and offer up a finding, it still goes back to the representation thing, right? Yes, the it's not required for the department to do it, but it's you would think that since it's a right, that the department would document somewhere that they offered the opportunity to reschedule because representation wasn't present. And I don't know, it just that may be the only thing I can hook onto. That I don't find it enough in terms of the timing. There's a disclarity there, but the hearing officer should not have proceeded if there's not representation. I mean, that costs. Their whole purpose is to hear this and to do something, just. And one of the first things someone's going to argue when there's not representation is that there's not representation, which is their right.
Are you making a motion?
So my motion is, well, the way parliamentary, it is the way it is.
We can discuss your motion once you
right.
make it, right?
That's true. So I would find that the department did not properly, that the department did not follow. The department did not offer an opportunity to reschedule the appeal.
Well, I think we didn't, the department.
That's what they said, but then they said no.
Okay.
And it didn't happen, and representation wasn't present. Those are the facts.
Okay.
Hi again. So when an employee, again, they have that right to request representation, but employees also have the right to decline representation with that same effort. Of course, it's a best practice. I agree with you that it's a best practice that once a person engages with representation, you should try to make accommodations where present. Now, again, I've gotten that clarification that it was afforded. In this case, it was declined. But even this question of representation and being processed is not a procedural flaw within the civil service rules. At least that's my argument anyway.
So, we've got a he said, she said thing going on here, right? And one question I have is there anywhere on the form that an appeal officer has to have a check mark that says employee declined representation? There should be, so that this doesn't happen again, and initialed by the employee. If there's a hearing about an appeal, that there should be some way to have documentation that the employee declined it. I'm just making a statement.
And well noted, and I'm sure in future departmental human resources officers training and moving forward with DHR, they may have that explicit request of like, hey, if a person has invoked their representation that they'd like to have present, please make sure that representation is present at, or note that they've declined or with a document.
I do have one quick, which could be our procedure, a little question. When she signed and dated it the 30th, was there a reason?
That was the date that she signed the form.
I understand, but the other dates were backdated.
Right. So the rater and the reviewer did sign on those dates that are noted on the performance appraisal. So in the packet that I've sent to the commission, and if you give us a minute, I'm sure we could bring it up, you could see the original signatures of the rater and the reviewer and the appellant, in this case, the employee, and it would reflect those same dates. So those dates translate into the final, as it is a final updated draft following the appeal process.
Okay,
the only additional signature is the appeal officer's signature, which notes that the appeal has concluded.
Got it. Thank you.
May I ask a point of clarification of counsel and staff?
Yes.
Do I understand it correctly that the employee would have the burden of proof in this particular proceeding?
I don't know that I would term it that way. Obviously, the employee has made the request. The employee is the one that's making the accusations about procedural flaw. So the burden would fall to them to come forward with information that shows that.
Because we're here, it's not the department's duty to defend their process. The employee needs to support their request ultimately.
I'm sure that the department does want to defend their process.
Certainly.
And they have. But I mean, the employee was the one that made the allegations.
So
Could you have you had in the past before employees saying, time out, I'm not answering any questions without a shop steward present?
Absolutely. That's under Weingarten. Yeah, they absolutely have the ability to stop any process without representation present. But again, not every county employee is also represented by a union. We want to be mindful about requiring union representation across the entire county in reflecting in your own decision as well, because we can't control, as a department, we can't control what is negotiated between unions and the county of San Diego, or if people have their own personal representation.
All right.
A question for council, or actually council. Section 5.1.7, investigation sealing of the appraisals. It's the civil service rules. Says if the commission finds such a violation, so it says the commission may investigate charges that an appraisal was either improperly issued or that the appraisal violates the rules or the county appeals officer's guidelines, human resources policies and procedure manual amended 927-5. If the commission finds such a violation, the commission may order all copies of the appraisals and the attached documents to be sealed. And the commission also may order that a new appraisal be prepared. There's a lot of ands in that, but there's an if there. So that does that say that if we find, like, we have to make a finding in order to do either that and that?
That's correct.
Okay. That's where I'm struggling and why I wish I could do something else, but I can't. Okay.
I make a motion that we take staff's recommendation to deny the request.
I'll second that motion.
No, sorry. What happened to the other motion?
I didn't.
You took it back?
Yeah,
You took it
there was
back?
no second.
Okay,
It's never seconded.
we have a motion and a second. Is there a discussion?
I mean, coming back to my question before, I think, Madam President, you said it, that it seems that we have a serious, he said, she said, and a lot of things that I would have liked to seen documented proof of, requests in writing versus, you know, maybe they occurred, maybe not. But I don't think we have that. I don't think we have a 51% threshold to make a finding that there was a violation here. So that would be my discussion on the motion.
All right, any other discussion before we vote?
A question for staff. Did we review the county's appeal officer guidelines?
They were included in the staff report.
And the staff report basically says that you do not find something that was against the, because it's not just a violation of the civil service rules. That rule says it's also, if there's a violation of the appeal officer guidelines, that could be the basis of a finding.
We did not find a violation.
Okay. Look, I generally, we're in discussion. Generally, I think the department should meet the same timeliness requirements as employees. So we've had discussions about this, but there's a pretty reasonable reason why that might not have occurred. I think that the department has a lot of things to look over in terms of the signature dates and things like that. That needs to be reviewed. And I wish it was done better. There's a lot of he said, she said, or whatever. They said, and I can't make a finding because I have no idea what happened. And if I could, then I would do something else. But I really don't like this. And the union representation thing is the biggest thing, in terms of a high-minded issue that I have with it. So look, I can't make a finding. I can't create a motion. There's nothing I can do about it. And I'll probably vote against.
Okay, I'll just make a comment as well, and we're in discussion. It concerns me. I used to be in HR as well, an HR consultant, and documentation is everything. This isn't the first time the commission has faced just incompleteness, lack of follow through. You said there's a gold standard. A gold standard shouldn't be just in rare cases that you follow it. This is like an ideal standard that we don't ever expect to meet. We should always be trying for the gold standard. So there's never an employee that feels like they didn't get their opportunity to talk to their supervisor about a performance appraisal that they didn't see coming. That's what bothers me, is that there wasn't an opportunity, and there still won't be, no matter how we rule, because the supervisor is no longer here. So with that, and that we cannot find
Finding.
any procedural thing that we can be certain you did not follow, I think it's time for a vote. So all those in favor of the motion?
No.
Oh, you do that. Sorry, I'm learning.
It's okay. We've done it else.
I have done it elsewhere.
Will
We
will the
clarify
Commissioner
the
Secretary
motion?
please record Commissioner votes?
Commissioner Bassett,
Point of privilege or order, whichever. Can we clarify the motion, please?
Yes, please.
I made a motion that we recommend the staff deny the request to seal. That was the staff's recommendation that we
Accepting.
accept the, yes, that we accept the staff recommendation.
And it was second.
and it was seconded.
Yes, okay.
All those in favor say
No.
aye. Oh,
No.
so start again.
Will the Commissioner
Chair
Secretary
minutes.
please record Commissioner votes?
Yes. Commissioner Bassett,
Aye.
Commissioner Coleman,
Aye.
Commissioner Montgomery,
Aye.
Commissioner Montenegro,
Aye.
Commissioner Rodriguez Kennedy.
Nay.
The motion passes. Thank you all for your time. I know it's not easy. And, you know, all I can say is let's do better, all of us, next time.
Okay, this concludes today's meeting. Thank you for attending. The next commission meeting is scheduled for February 4th, 2026. This meeting is adjourned. Thank you.